Breaking news. No more automatic extensions of work permits. My name is Henry Lindpere and I'm the Senior Immigration Counsel here at Manifest Law. I'm going to break down the recent new rule that came out today from DHS about EAD cards, and I'm going to explain its significance for employees who rely on EAD cards and employers who hire people who have EAD cards. Now, normally, when somebody has an EAD card to prove that they're authorized to work in the United States, then as long as they apply for an extension before the current card expires, they would get an automatic extension, meaning that they would be allowed to keep working even if USCIS has not yet approved the new card. The new rule that came out today and goes into effect after midnight tonight changes that. And it means that moving forward, if you apply for an extension, even if you do it before your current card expires, you don't get an automatic extension of your work authorization. So if you don't apply early enough, or if USCIS does not process the EAD application fast enough, then there might be a gap in your work authorization. If your current card has expired, the new case has not been approved yet, then you do not have the authorization to keep working, and your employer must stop the employment. Otherwise, they also break rules on hiring somebody without work authorization. Here are the biggest categories and who is impacted by this rule. But first, who is not impacted by this rule? Okay, TPS. If you are a beneficiary of TPS, then as long as DHS keeps updating the website where they show that the TPS rules are extended for a specific country, then TPS holders are still eligible for the automatic extension. The bad news is that almost all other categories are covered. So the biggest ones that most people are going to care about are things like adjustment of status applicants, right? So if you've applied for adjustment of status, you're waiting for your green card, but you don't have it yet, then you can get an EAD card to have unrestricted work authorization while you're waiting for your green card. Now, usually that category had that automatic extension, so you could keep working, however many months or years it takes for USCIS to process the adjustment of status. This new rule is going to impact most harshly many Indian applicants who filed for adjustment of status several years ago, and then their priority dates on the I-140s retrogressed, and USCIS has not been able to actually approve their adjustments. There's many people like that who've been waiting for their adjustments to be done for 3 years or even 5 years. So in that situation, it's likely that at some point your EAD expires and you need a new one. So if you're one of those people, that means you should really watch the expiration date on the EAD and apply as early as you can to minimize the chance of USCIS taking longer than your expiration date to process the renewal. Second category that's very common is people with pending adjustment, or not pending adjustment, pending asylum case. The second category that's very common is people with a pending asylum application. So people who apply for asylum but haven't been granted asylum yet, they spend years waiting for their asylum interviews because the processing times are so long. We know people who've been waiting for 7-8 years maybe for their asylum interview, and they still haven't had one scheduled. So if you are one of those people and you've been here for many years already, that means you probably have already applied for EAD cards multiple times, and that automatic extension is really valuable there. Now, again, you need to watch those expiration dates, because otherwise you're going to have a gap in your work authorization, and that might impact your eligibility for asylum if you work without authorization. Third category that's going to be really strongly impacted here are H-4 spouses with EADs. So if somebody is here on an H-1B visa and they have an approved I-140 petition, that means they're on the wait list for green card, then their spouse can apply for an EAD. There's a lot of hundreds of thousands of people like this, many people from India, for example, because India is the biggest recipient of H-1B visas. And why this is so complicated for H-4s particularly is because in order for an H-4 spouse to apply for an EAD, first the H-1B must extend their status, then the H-4 must extend the H-4 status, and then they apply for the H-4 EAD. So that means that you have to really carefully plan in advance to make sure that the H-1B has been extended, maybe even use premium processing for the H-1B, because a lot of companies are renewing H-1B visas for with regular processing because they get an automatic extension on the H-1B. But now it's actually very valuable for you to get the H-1B done fast so that the spouse can then apply for the H-4 extension and EAD, or bundle it together. But as you know from earlier this year, USCIS is not processing them all together. So even if you file them together, it's not necessarily going to all be approved at the same time. So these are the biggest categories, but overall, like I said, almost all categories are impacted. What can you do about it? If you are one of those categories that is eligible to file for an extension online, for example, if you have an asylum pending or if you are on DACA, then you can actually, if it's less than 6 months until your current card expires, you can go to myuscis.gov today and submit an electronic application for the I-765, the employment authorization form. That means it can be received today, and then that notice will still be valid evidence of an automatic extension. But for any other category that's not available to file online, or if you have more than 6 months left for your EAD, then the next step is watch carefully the expiration dates of the EAD. In general, most cases, USCIS accepts EAD applications up to 180 days before your EAD expires. So if you have an EAD that's expiring in 5 months or 7 months or anything, 9 months, whatever, then file as soon as you are eligible to file, whether that's electronically or on paper, to give USCIS the maximum amount of time to process the case. That way you minimize the chance that your EAD expires while USCIS still hasn't approved the extension. Next up, how does this impact employers? It's a big change for employers' I-9 compliance. So if you work in HR or you run a startup and you're starting to think of hiring more people, you probably already know that when you hire people, you have to do the I-9 form to verify that the person you hired is eligible to work in the United States. And when it's somebody with an EAD card, then you have to note the expiration date on the I-9, and when their EAD expires, you need to redo an I-9 to check if they've gotten an extension of some sort. And previously, you would have just checked their expired EAD and the receipt notice showing that they've applied for an extension, and you were fine. But now with this new rule change, you have to know that the receipt notice alone is not going to be good enough for majority of categories, and you need to first be aware what is valid proof for the I-9, and you need to make sure that if somebody does have an expired EAD and they don't have a renewal approved yet, then they need to stop working. You need to take them off payroll, and you need to bench them because the company can get into a lot of trouble with audits, penalties, and fines for employing somebody who does not have actually authorization to be employed. Secondly, your whole HR system needs to be recalibrated to account for these new changes. So if you have people on EADs working for you, instead of leaving it to the last week or the last month of the expiration date just to check with them if they've applied for a renewal, you should calendar 6 or 7 months before that and check in with them. And if they don't have plans to renew yet, then push them to renew as soon as possible. So that means like notification systems, software, logic internally on the systems, all of that should be reconfigured to account for all of these new changes. Big picture difference, this new rule really shifts the burden of the government processing times getting longer and longer onto the employers and the employees rather than on USCIS. So now we're going to have more people who are stressing out about processing times and renewals, and we're going to have employers who have to spend more time and money on a more complex and more expensive compliance structure to make sure that you are not breaking any rules. If you found any of this helpful, then please like, comment, subscribe, follow us on social media, YouTube, Instagram, anywhere you can find us. Check us on manifestlaw.com, and if you need more specific advice, contact us for a consultation as soon as possible. Thank you very much.